Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Admiralty Law in India. A ship may be arrested 1. To acquire jurisdictions, or 2. To obtain security of satisfactions of the claim when decreed, or 3. In executions of a decree. In the first two cases, the court has the discretion to insist upon security being furnished by the plaintiff to compensate the defendant in the event of being found that the arrest was wrongful and was sought and obtained maliciously or in bad faith. The claimant is liable in damages for wrongful arrest. This practice of insisting upon security being furnished by the party seeking arrest of the ship is followed in the United States, Japan, and other countries. The reason for the rules is that a wrongful arrest can cause irreparable loss and damages to the ship owner, and he should is that even compensated by the arresting party. See Arrest of the Ship by Hill, Soering, Horsoy, and Helmer. The attachment by the arrest is only provisional and its purpose is merely to detain the ship until the matter had been finally settled by a competent court. The attachment of the vessel brings it under the custody of the marshal or any other authorized officers. Any interference with the custody is threatened as the contempt on the court which has ordered at the arrest. But the marshal's right under the attachment order is not one of possessions, but only of custody. Although the custody of the vessel has passed from the defendant to the marshal, or the possessory right which previously existed continued to exist, including all remedies which are based on possession. The warrant usually contains a motion, admonitions to all persons interested to appear before the court on particular day and show cause why the property should not be condemned and sold to satisfy the claim of the plaintiff. The attachment being only a method of safeguarding the interest of the plaintiff by providing him a security is not likely to be ordered if the defendant or his lawyers agrees to accept service and to put in bail or to pay money into court in lieu of bail. A personal actions may be brought against the defendant if he is either present in the country or submits to jurisdiction. If the foreign owners of an interested ship appears before the court and deposits security as bail for the release of the ship against which proceeding in rem have been instituted, he submits himself to jurisdiction. An action in rem is directed against the ship itself to satisfy the claim on the plaintiff of the rest. The ship is the purpose treated as a person. Such an action may constitute an inducement to the owners to submit the jurisdictions of the court, thereby making himself liable to be proceeded against by the plaintiff in personam. It is however imperative in an action in rem that the ship should be within jurisdiction at the time the proceedings are started. A decree of the court in such an action binds not merely the parties to the writ of property in the ward who might dispute the plaintiff claim. It is by means on actions in rem that the arrest of a particular ship is secured by the plaintiff. He does not sue the owner directly and by name, but the owner or any interested on the proceeding may appear and defend. The writ is issued to owners and parties interested in the property proceeds against. The proceeding can be started in England or in the United States in respect of a maritime lien, and in England in respect of a statutory right on in rem. A maritime lien is privileged claim against the ship or a right to a part of the property in the ship. and it travels with the ship. Because the ship has to pay for the wrong it has done, it can be compelled to do so by a forced sale. In addition to maritime liens, a ship is liable to be arrested in England in enforcement of statutory right in rem Supreme Court Act 1981 if the owner does not submit the jurisdiction and appear before the court to put in bail and release the ship. It is liable to be commanded and sold to satisfy the claims against her. If, however, the owner submits the jurisdiction and obtains the release of the ship by depositing security, he becomes personally liable to be proceeded against in personam in executions of the judgment if the amount decreed exceeds the amount of the bail. The arrest of the foreign ship by means of an action in rem is thus a means of assuming jurisdictions by the competent court. The common law of India Bullet 2. Two Indian states lag behind international law. In this context, the principle in this convention derived from the common law of nation will be treated as a part of the common law of India. Paragraph 76 in this behalf reads under: It is true the Indian states lag behind the development of Indian law in comparison to contemporaneous states in England and other maritime countries. Although the Hague rules are embodied in the Carriage of Goods by Sea Act, India never became a party to the international conventions laying down those rules. International conventions for the unification of certain rules of law relating to bills of lading, Brussels, 1924, the Carriage of Goods by Sea Act 1925 merely follow the United Kingdom Carriage Goods by Sea Act 1924. The United Kingdom repealed the Carriage of Goods by Sea Act 1924 with a view of incorporating the FISB rules adopted by the Brussels Protocol in Protocol of 1968. The Hague FISB rules were accordingly adopted by the Carriage of Goods by Sea Act 1971 in the United Kingdom. Indian legislation has not, however, progressed notwithstanding the Brussels Protocol of 1968 adopting the FISB rules of the United Nations Conventions on the Carriage of Goods by Sea 1978 adopting the Hamburg Rules. The Hamburg Rules prescribe the minimum liabilities of the carrier for more justly and equitably than the Hague Rules so as to correct the tilt in the latter of the favor of the carrier. The Hamburg Rules are acclaimed to be great improvement to the Hague rules and far more beneficial from the point of view of the cargo owners. India has also not adopted the International Convention relating to the arrest of seagoing ships, Brussels 1952, nor has India adopted the Brussels Conventions of 1952 on civil and penal jurisdiction in matter of collision, nor the Brussels Conventions of 1926 and 1967 relating to maritime liens and mortgage. A. International Conventions relating to the arrest of seagoing ships, Brussels, May 10, 1952. The International Conventions on certain rules concerning civil jurisdiction in matters of collision, Brussels. C. International Conventions for the unification of certain of collision, Brussels. D. International Conventions for the unification of certain rules relating to maritime liens and mortgage. India seems to be lagging behind many other countries in ratifying and adopting the beneficial provisions of various conventions intended to facilitate international trade. So that's all the article. Bye bye and Don't forget to like, comment, and subscribe. And also don't forget to watch my previous video, and bye bye.